Good afternoon, ladies and gentlemen, and thank you for the opportunity of discussing priority notices under the Land Title Act. It has been suggested that the introduction of priority notices to the Land Title Act has created an effective, efficient and inexpensive mechanism for protecting unregistered interests in land, and that with the rise and expansion of e-conveyancing, caveats may be a thing of the past. Here's just a brief introductory fact. Despite its free market image, all the land in Singapore is owned by the government, and 85% of housing is provided by a government-owned housing corporation. Now, like this fact, all is not as it appears with priority notices. So, what is a priority notice and how does it differ from a caveat? A priority notice is a notice lodged against a title to reserve priority for a pending transaction affecting that title. A priority notice can only be lodged electronically, and when lodged, will give notice of the purchaser's interest to prevent registration of a subsequent dealing. It is generally understood that lodging a priority notice requires a legal or equitable interest in the subject land, similar to a caveat. A priority notice, when recorded on the title, has a twofold effect. It reserves priority for the transaction set out in the notice and alerts parties searching the title that an imminent transaction is to be lodged against that title. The objectives of introducing priority notices include providing greater certainty to the transaction for which priority is reserved, alerting interested parties who search the register that an intended transaction is pending, provides increased assurance to the parties involved in the settlement of the interest, and assists in fraud prevention, as details of a pending transaction will appear on a search of the register. So let's consider an example. A enters into a contract to purchase land from B. Settlement is 30 days. B has an existing mortgage on the property. The transfer form is signed by both parties in preparation for settlement. The release of mortgage is obtained in order to give clear title. Before settlement, B, however, borrows further funds or decides to borrow further funds against the land. He signs a second mortgage with Mount Gambier Bank. A lodges a priority notice which gives notice of imminent settlement following the release of the mortgage and transfer. This will prevent registration of Mount Gambier Bank's mortgage. A priority notice differs from a caveat in that a caveat prevents or prohibits the registration of certain dealings pending the perfection of a claimed estate or interest in land, whereas a priority notice gives priority to the registration of specified unregistered dealings for a limited period of time. The caveat is a warning to any other party searching the land title that the person who lodged the caveat on title has an interest in the land. Subsequently, it prevents any further dealing with the land until that person or a court has removed it. So, an example of a caveat. It may be that the owner of the land owes money to a builder. In that instance, the builder, who is a creditor, has registered a caveat on the title of the property as a warning that the title is not clear. The merits of priority notices include they are cheap to register and withdraw, they are quick and easy to lodge, they will appear on any search of the relevant title. A caveatable interest is not needed in order to register a priority notice. All that is required is that you are a party to a land dealing. It gives notification to the world of an intended dealing. It may be lodged in respect of any intended dealing. It temporarily prevents the registration of any other dealing. It gives priority for 60 days from recording of the notice on the register. And finally, sequential priority notices can be lodged without limit in relation to the same land dealing. Now, on the other hand, unlike a caveat, a priority notice is time limited and does lapse. Priority notices do not prevent registration of all subsequent dealings. For example, a caveat is not subject to a priority notice, and there can also be competing priority notices. It cannot be amended. Consent cannot be given to registration of a dealing not protected by the notice. It can be withdrawn and relodged, but priority will be lost to any dealing awaiting registration. It lapses after 60 days, and a subsequent competing dealing lodged in the 60-day period will be registered immediately the priority notice expires. Caveats appear to provide all of the benefits of priority notices and few of the disadvantages, in that caveats may be amended, consent can be given to registration of a dealing, and they do not automatically expire. It is this latter point that must concern lawyers. 60-day settlements are common, as are 90-day settlements. Both can unexpectedly blow out, and so lodging a priority notice when entering into a 60 or 90-day contract may find the priority notice expiring before final settlement, thus leaving the transfer unprotected. If you lodge a notice 30 days prior to the anticipated settlement date to overcome this problem, it leaves the prior contractual period unprotected. I consider the automatic lapsing feature to be one of the main pitfalls of the priority notice. When a priority notice is registered, subsequent dealings lodged for registration are noted on title as unregistered dealings until the dealing subject of the priority notice is registered or the priority notice lapses or is withdrawn. The ability to lodge consecutive priority notices for the same dealing does not appear to prevent other unregistered dealings being noted on the title, consequently registering immediately upon the lapse of the priority notice and before a second priority notice can be lodged. This is clearly unsatisfactory if the dealing for which I am trying to preserve priority cannot be registered within the priority notice period for whatever reason. So, while many have pondered whether caveats will lose their relevance with the introduction of the priority notice, I believe that if there is a caveatable interest, it may well be more prudent to lodge a caveat than a priority notice, particularly if the registration date of the dealing cannot be predicted with any certainty. The beauty of a caveat is that it remains on title indefinitely, preventing virtually all dealing with the title until it is either withdrawn or is lapsed by the owner or another interested person seeking its removal. A caveat gives strong protection for the priority of a proposed dealing. Even though the priority notice and caveat have distinct purposes, the priority notice merely preserves the priority of a specific dealing. that is to be lodged for registration at a later time. The caveat, on the other hand, acts as a form of security or shield and a warning to third parties that the caveator has an equitable or legal interest in the land and can be used to protect the priority of an impending dealing. In my opinion, where that caveatable interest exists, registering a caveat is the safer bet, even though it costs that little bit more. So, to recap, caveats are used to freeze the register to protect unregistered interests in land. Priority notices preserve a place in the queue for proposed dealings, such as transfers, mortgages, leases, etc. In conclusion, although priority notices are undeniably a quick and cheap tool that can be used to preserve a future dealing's priority on title, one must also carefully consider whether the relevant dealing will in fact be registered within the priority notice period, and, if the circumstances permit, whether a caveat should be lodged instead. One last fact. There are legal, soundproofed oil rigs hidden as office buildings in some Californian cities in the United States. Thanks for listening.